Hello, everybody. I welcome you all to the daily newspaper analysis, an initiative of the UPSConline.com and Ambition IAS. Today, we'll be discussing the newspaper of the 13th of December 2017. Coming to the first article, Information at the Court's Discretion. This is an article on the editorial page and is by far today's most important article in the Hindu newspaper. Now, the article is basically about the ongoing debate upon RTI versus judiciary. Now, this is a very hotly debated topic and is important from a number of perspectives for UPSC. So, considering the importance of the article, we will not only restrict ourselves to the editorial today, but rather I'll be giving you some additional information on this topic. So, let's start. Coming to the background part of this article. First and foremost, you all know that the RTI Act was implemented or it was enacted in 2005, which made information a right of all the citizens of India, and it was applicable to all public institutions. So when the law has been implemented for all public institutions, judiciary doesn't stand outside its ambit. This needs to be understood. Judiciary itself is a public institution, and the moment RTI has been introduced, judiciary automatically comes under its ambit, until and unless judiciary claims that it is not a public institution, which is not the case. Also, under RTI, there is a provision of something called Section 8, which is for all the exceptions under the RTI Act. There is a provision, there is a section which discusses all exceptions. So judiciary has always been claiming that some of its information is highly secretive and it's highly confidential and it cannot be released under RTI. So we have to understand that the RTI has a provision for such information, and if judiciary claims that its information is confidential and cannot be released, so that is well covered by RTI. So such claims are automatically cancelled out. Now, coming to the second point, which has been raised in the article itself, the judiciary has laid claim to something called the Supreme Court rules, which were implemented in 1966. Now, judiciary says that any information that the judiciary is liable to produce is going to be under these rules. However, you have to understand that there were many such rules even before the RTI for various other sections. For example, even for executives, even for states, there were state level RTI information rules. But the Act itself, the right to information, has made divulging information a right of the citizens. And the moment RTI has been introduced, all previous laws relating to information automatically are subsumed under the RTI. But the judiciary holds a different stand altogether. Now, also, the author has mentioned a case in the context of which this article has been written, is that there was a case in 2010 when a person named K.S. Misra had filed an RTI application in the court, and this was rejected by the court. And further, when he filed an appeal for this to the Chief Information Commissioner, who then was some Mr. Shailesh Gandhi, at that time, the Chief Information Commissioner gave a decision in the favor of Mr. K.S. Misra. This made the entire matter get under the ambit of Delhi High Court, and for 6 years it was under the Delhi High Court, and now the Delhi High Court has given its decision. So this is the current issue, and it has cancelled the decision of the Chief Information Commissioner. So this is the present controversy. Another thing that can be added to the background is that last year there was a case by Mr. Subhash Agarwal, who filed a case in the Supreme Court about bringing the appointment of judges under the ambit of RTI. And for this, there was a constitutional bench that came and had to give its decision. The decision is yet to be given. But so you have to know that there was a case also by Subhash Agarwal. Now this is not in the article, so if you want to note this down, you can note this down. Subhash Agarwal case. So this is the background of the entire issue. Now, coming to the application and the issues that are involved in this matter, I shall be discussing application and issues together because they are highly overlapping. So first and foremost, as per the article itself, there's a comparison between the RTI versus the Supreme Court rules of 1966. Now, the Supreme Court has always taken a stand that the Supreme Court rules and RTI are largely they are largely consistent with each other. However, closer look reveals that there are many differences between the Supreme Court rules and the RTI. The differences are, firstly, that the Supreme Court rules do not have any timeline for information. And as we all know, that RTI is time-bound, information has to be provided. Secondly, there is no appeal mechanism under the Supreme Court rules. Thirdly, there is no penalty for delays or any wrong information given under the Supreme Court rules. And lastly, disclosure of information under the Supreme Court rules depends on a clause, or depends upon a subjective interpretation of something called as good cause shown. Now, under RTI, we all know that there is no such clause of a good cause shown, and all information that is in the public domain has to be made available by somebody called the Public Information Officer. So this clearly represents that how Supreme Court rules are very much not consistent with the modern RTI, which is much more advanced and much more citizen oriented. So we have to understand these differences. Now, coming to the second issue here is that opacity in judiciary. Now, opacity in judiciary is a debate that has been continuing for very long. Also, recently in the NJAC case, we all know that the executive had raised questions upon the opacity in judiciary, especially with regards to appointments in judiciary and also decision making. See, not the decision of courts, not removing the judicial decisions aside, the administrative decisions of judiciary are outside the ambit of RTI or even outside executive checks. So the question here is that judiciary has been operating in a very, very opaque manner. So this makes judiciary a very difficult institution to tame. So this is the question that is being raised in this article again. Now, thirdly, there is a moral question associated. Now, this is something that you can also use in your ethics paper. The moral question raised here is that the Supreme Court, or for that matter, the High Court, or judiciary as a whole, has always been championing the cause of RTI. It has always directed the executive and other bodies to always be open and transparent and accountable. Whereas when the question of its own transparency and accountability has been raised, the court has always taken a protectionist stand. And so the issue here is that how can you tell somebody else to be transparent when you do not wish to be transparent yourself? So this is a moral and ethical question that is raised in front of the judiciary. Also, another thing that is there is that in any form of law, the idea is that nobody can be a judge of his own case, and in this scenario the courts are acting as a judge of their own case. How can the judges themselves decide that whether they should come under the ambit of RTI or not? So this is another technical issue which needs to be brought up here. Now, another issue is that of relevance of RTI. RTI, is in your syllabus and in polity and governance in paper 2. And not only there, even in essays and various other topics, RTI is a very, very crucial piece of information and piece of example that has to be used in UPSC. Now, what is the relevance of RTI if time and again it's going to be floundered the way it is? See, political parties have refused to come under the ambit of RTI. Judiciary refuses to come under the ambit of RTI. And recently there was also a situation where for a long time the Chief Information Commissioner was not appointed by the government. So you have to understand that if there is going to be a continuous meddling with the RTI, then people will lose their faith in RTI. And RTI in India has come through a people's movement. And if such activities continue, then definitely the act itself is going to get undermined and it's going to lose its relevance. So you can even have a direct question that what is the status of RTI? It has come in the past. You can again expect some such kind of an analysis in the UPSC paper. So next issue is that of judiciary versus executive. Now this is again a very much debated issue. Judiciary has always been out, forward in chiding the executive, or for that matter criticizing them openly, making them more transparent, making them more citizen oriented. And the executive, on the contrary, has also been critical of the judiciary. This was very much in the open during the NJAC debate. So in such a scenario, when one law is being applied to executive and not to the judiciary, it amounts to a bashing of executive. It demoralizes the executive. So there are many such issues involved. So those have to be considered under this topic. Now, another thing is that of judicial reforms. Definitely, India is very much in need of judicial reforms. You can see that from the from various dimensions. Firstly, the appointment of judges. Secondly, the functioning of judiciary, the bureaucratic procedures in the judiciary, the delays in cases. All of that clearly reflect that the judicial system in India is very much in need of an overhaul. So whenever there is an opportunity for you to present some ideas on judicial reforms, this is a good idea. That judiciary should come under the ambit of RTI, and that is going to be a major reform for judiciary. So this is how this article has to be understood and applied. Coming to the next article. Now, this is an article which says that human rights and Indian values. Now, the opinion of the author is very much clear over here. He says that neither civilizational ethos nor the mere enshrining of constitutional morality is enough to deliver on basic rights. Now, basically, the article is about human rights, considering that 10th of December is the National Human Rights Day. So, the article has been written in that backdrop. The background part is simply that on this day, Vice President of India had given a speech, and he had said that human rights in India are not merely a constitutional guarantee, but they are also a part of our civilizational behavior. He had even used a Sanskrit quote where he said that Sarva Jana Sukhino Bhavantu, which largely means may all be happy. So such kind of Sanskrit words and all are useful even in essays, and they are useful even in ethics papers, so you can make a note of them. Now, the author asserts that the vice president's speech is not validated. He has countered the vice president's speech and said that in the backdrop of episodes like the Dadri lynching, the Alwar lynching, the Rajsamand murder in Rajasthan. So now these examples that the author has given, these examples are somehow important even for UPSC, though you may not take the names of the victims, which are evidently mentioned in this editorial, but you can avoid them in UPSC. But these cases like the Dadri lynching, or the Alwar lynching, these can be used in examples. Also, presently intolerance is a major issue in India. And definitely some scope, some opportunity for analysis in the UPSC paper on intolerance can be expected, and there these examples can come handy to you. So you must remember that. Now, the author makes a point that all these lynchings that he has mentioned are largely targeted against the Muslims. So this clearly reflects that there is an intolerance in the society. So this is the background part. Now coming to the issues, the author has very much clearly in his opinion only stated that the human rights are not a part of civilizational ethos. Now, how did the author justify this in this article? He says that something civilizational, though definitely India has a civilization which has a number of moral values, but not all civilizational ideas are in line with human rights. For example, casteism in India, that is a civilizational aspect, and this is not in line with the human rights. The treatment of women, the patriarchy in our society. So these are all examples that how civilization is not a barometer for measuring human rights. So this is how the author has dismantled that view. Now coming to the next view is that of constitutional morality. The author clearly states that constitutional morality means certain rights which have been enshrined in the constitution. And we all know that India has a huge legacy of fundamental rights, and India has some of the strongest rights enshrined in its constitution. But the author states that these rights are clearly not functioning well because the current scenario clearly reflects intolerance, it shows crime against women. So how the constitutional rights in themselves are simply a golden word and not have no spirit, until and unless the author asserts that until and unless they are backed by a strong government and good governance, only then are these rights of any value, or else these rights are immaterial. So this is how the author has given his opinion. Finally, the author has also said that the idea of human rights, he has not only limited himself to human right, but he has expanded his opinion from human rights to economic and social rights. And he has said that in India, human rights, social rights, and economic rights have achieved some particular success because of democracy. And democracy, he says, is not something that is civilizational to India. It is a foreign concept which India adopted after its independence. So clearly, this proves that how civilization is not the only source of human rights, and a source outside the civilization, something like democracy, can also bring about rights in a country. So that is the opinion that the author has made. Now, in the last paragraph of this article, the author has come up with a warning where he has given a case study by a Canada-based economist named Mukesh Iswaran, and he says that the economist has made a study, and he has opined that terrorism in large part of the world is largely, especially in the Muslim countries, is because of the historical wrongs that have been committed against these countries and against these people. Now you have to understand that this was an opinion that was also reiterated by the former president of US, Mr. Obama, and he had also asserted that if you have to truly root out terrorism, then you have to go to the core problem of terrorism, which is this antagonism that has developed amongst a large section of people. So the author has warned that if there is a continuous environment of wronging to a particular community, it can backfire. And the author has warned the country that such activities of intolerance that are happening in India can backfire and can marginalize a particular community and make them against the nation. So this is one warning that the author has given. Now coming to the application part of this article. Now basically it is a social issue, because intolerance is a social issue. It is targeted against a particular community, a religious community. So this makes it a social issue. Also, it is about the rights of people. So again, it's a social issue. Now it can be used in the polity and governance paper. How? See, whenever because the author has mentioned about constitutional rights, and he says that how constitutional rights are not sufficient within themselves, the article becomes important from political aspect. And author asserts that it is good governance which is going to implement the polity. So that is how governance as a means to achieving the ideals of constitution has been enshrined by the author. So that is how it becomes important here. Lastly, this is important from ethical point of view. Why? Because in ethics there is something called civilizational values. Now sometimes you have to analyze in the ethics paper that how civilization has a role to play in morals and values, and this part has been discussed by the author where he negates the importance of civilizational values. So in that part of the ethics syllabus, this can become important, so you can use it use it there. Coming to the next article. Now this is a small article which is perils of going cashless. Now the article has been written in the context of the Financial Resolution and Deposit Insurance Bill, which is expected to be introduced in the winter session of the Parliament. Now this bill has a clause that is bail-in issue. Now as per this clause, you must have heard of this term bail-out. The term bail-out means that if a bank, suppose, has failed or a company has failed, then the government can use the taxpayers' money and bail it out. All right. Now, contrary to this idea, there is another issue called the bail-in issue. And this here means that suppose a bank has gone bankrupt. In that case, the money of the depositors that the bank has can be used to revive the bank. So this is a very, very contentious issue, because this makes the depositors highly vulnerable in such a scenario. And this is something that is being objected to. And also this becomes important in a cashless society, because the government has been thrusting more and more citizens into going cashless through various schemes like the Jan Dhan Yojana, now the recent demonetization. This has made every single individual to have a bank account and to use the banking sector. So financial inclusion has been a great achievement of this government, truly, but if all the citizens are linked to the banks, then such a provision of a bail-in makes all these citizens also vulnerable to bank failures, and such provisions which this bill is envisaging. So you have to understand this one criticism of the bail-in issue. Now, secondly, going cashless and its impact on banks. The author has discussed this under two criteria. Firstly, what can happen is that because the economy is going to get cashless, so people will not need cash per se. So people will not go to banks for withdrawing cash. So what banks can do is they do not need that much amount of liquidity to be maintained, and this provides a bubble around these banks that even if they do not have the liquidity, they do not have the support to provide the depositors, they can keep going in for lending credits. So this again makes depositors vulnerable in such a scenario. Now, even if the banks are giving credits continuously, it's going to make credit cheaper. The people who have deposited their money in the banks will not be able to reap high interest because credit will become cheaper. So obviously interest on deposits is also going to reduce, but people will not have no other way because it will be a cashless economy. So cash will not work. So they will have to work through banks only. So they will not have no other way to they'll be rather trapped with the banks. They'll be forced to keep their money in the banks despite low interest. So that is another problem of cashless economy. This is also the impact that is going to be there on individuals. The idea is that individuals will get trapped with the banks. That is the whole idea of this article. Now, basically, the application of part of this article, or the opinion part of this article, is that, see, for Indian economy to get absolutely cashless, it is a long way. It is not going to get absolutely cashless immediately. So that is one thing. Now you can use this article, see, but generally one has to always take an opinion on cashless economy, that it is good because it undoubtedly it has a number of advantages for the economy. But somehow you can sometimes be able to be asked to critically examine cashless economy, and this is a rare article which shows you some of the disadvantages of a good idea. So that way this article becomes important. I think that's about this article. Now coming next to the WTO, as I told you that it's the 11th Ministerial Conference of WTO going on in Buenos Aires, Argentina. A separate video on WTO has been made which covers all the aspects. Some new updates to that video I just read in today's newspaper, so I've included this slide. First and foremost on e-commerce. Now you have to understand that there's something called new issues. All of these are new issues. India has given these issues a name called as new issues, and India has taken a stand that it is not going to discuss any of the new issues until and unless past commitments and past issues are cleared in the WTO forum, about which I have mentioned in the previous video. Now, with regards to e-commerce, there was a slight opinion, which was a good opinion. India has taken a stand that e-commerce is largely 95% domestic and only 5% of it is international. Now, even if from your personal experience, you should know that the e-commerce that you people are using like Flipkart and Amazon, they are domestic e-commerce. And you are not ordering something from a foreign country that is coming to your doorstep. Even if there are such provisions, it is only 5%. So India has taken a stand that because it is only 5%, a global rule based agreement on e-commerce is not needed as of now. Also, India has said that because only few countries have this sector of e-commerce fully developed, like Japan, US, China, so these countries will have an undue advantage and undue leveraging at this point of time, and so India has clearly denied its support for any agreement on e-commerce. Another issue that is another new issue that is there is investment facilitation. Some countries have proposed that there should be global rules on investment, which India has denied because India has said that it's going to affect its sovereignty on investments, and India is also welcoming investments. So at this point of time, India doesn't want many rules and wants some sovereignty, and also some rules on small firms, which can be in India's interest, but India has taken a stand at the WTO that it is not going to discuss any new issues until its concerns regarding food security, public stock holding, agreement on agriculture and subsidies, all of these things are addressed, and also the Doha Development Agenda. These issues are addressed. Only then will India go ahead with any of these new issues. So that's about it for today. I thank you all for watching this video. I hope it's of some use to you. I request you to recommend this video to your friends, and we will welcome all your feedback, reviews and comments.